Aloha mai kakou. Good morning. This is the January 20th, 2022 Land Use Commission meeting, which is being held using interactive video conference technology, allowing members of the commission and other interested individuals of the public to meet via the Zoom internet conferencing program. We're doing this, of course, to comply with state and county official operational directives during the ongoing COVID-19 pandemic. Members of the public are able to view the meeting via the Zoom webinar platform. As I said yesterday, I would like to remind all participants to speak slowly, clearly, and directly into your microphone. Also, please be aware that this meeting is being recorded and transcripts are being generated from the recording of this event. The result of that is two distinct things. First, for the transcripts, it really helps if you state your name before speaking. Secondly, please be aware that because this is being recorded, your attendance is your implied consent to be on the official recording of this meeting. If you do not wish to be part of the official recording, you should leave this meeting now. As we know, this Zoom technology allows the parties each individual remote access to the meeting via our own individual devices and connections. Because of this, and because of sometimes matters entirely outside of our control, occasional disruptions to connectivity may occur. If this does occur, please speak up, let us know, and please be patient as we try to restore audiovisual signals so we can continue to conduct business during the pandemic. We closed public testimony on this matter yesterday, so there will be no additional public testimony. We will continue to take breaks from time to time. Roughly speaking, we have from 9:30 till 11 today, so I actually do not anticipate taking a break for the next hour and a half. We'll try and get through as much as we can. If we have to go beyond the 11 o'clock hour, we will take a 2-hour recess between 11 and 1 when we will lose quorum. And then we will resume at 1. My name is Jonathan Lekeke Scheuer. I have the honor and pleasure of serving as the Land Use Commission Chair. Along with me, Commissioner Don Chang, Commissioner Arnold Wong, Commissioner Edmund Axon, are all on the island of Oahu, along with our small but incredibly talented staff, our Executive Officer, Daniel Ordenker, our Chief Planner, Scott Derrickson, our Planner, Riley Hakoda, our Chief Clerk, Natasha Quinones, and our Deputy Attorney General, Linda Chow. Commissioner Lee Ohigashi is on Maui. Commissioner Dan Giovanni is on Kauai. Commissioners Gary Okuda from Oahu and Commissioner Nancy Cabral from Hawaii Island have both recused themselves from this docket. With that, today's item is a continuation of an action item for docket SP 21413, Connections New Century Public Charter School / Community-Based Educational Support Services, Hawaii, to consider a special permit application for the Connections New Century Public Charter School Community-Based Educational Support Services, SPP 12-000138. Will the parties please identify themselves for the record, starting with the school?
Good morning, Chair and Commissioners. Kevin Richardson, Deputy Attorney General, on behalf of Connections New Century Public Charter School. Also with me is Romeo Garcia, Principal of Connections, and he is located on Hawaii Island.
Mahalo.
Morning. Morning, my name is Ted Hogg. I represent the petitioner CBES. With me this morning is CBES member John Thatcher.
Windward Planning Commission.
Good morning, Malia Kekai, Deputy Corporation Counsel representing the Hawaii County Windward Planning Commission.
County of Hawaii Office of Planning.
Good morning, Dean Campbell, Deputy Corporation Counsel, and with on behalf of the Hawaii County Planning Department, and with me is Deputy Planning Director Jeffrey Darrow.
Okay, thank you. Office of Planning and Sustainable Development.
Good morning, Allison Kato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here are Rodney Funakoshi and Lorene Maki from OPSD. Thank you.
Thank you. And intervener.
Michael Matsukawa for the intervener, Jeffrey Gomes.
Thank you very much. Okay, just to briefly update the record, as promised at the end of last meeting, Mr. Hong, on behalf of CBES, sent a written response to commissioners' inquiries, and those were emailed to Riley Hakoda. And I want to confirm with either Riley or Ms. Quinones, those responses have been posted to the LUC website.
Good morning, Chair. This is Natasha. The response was posted to the website, and I believe Riley had forwarded those to the parties as well.
Did any of the parties not receive this communication? Okay, seeing now. I'm going to provide a brief opportunity for the parties to make any final comments and commissioners to ask any final questions before we move into deliberation. So we'll go in the same order, starting with Mr. Richardson.
Thank you. I just wanted to address 2 points that came up during the testimony. And the first one is that Connections is not a private developer, nor is it a state agency with adequate resources. I believe this was raised by you, Chair. Funding for development projects is very limited for charter schools. They receive per pupil funding as allocated by the legislature, but that funding has a deadline. And so for any long-term development projects, Connections has to rely on either fundraising by its nonprofit CBES, specific legislative appropriations, or loans and grants like the USDA loan that was mentioned in the application. However, appropriations from the legislature or procuring grants and loans are generally conditioned upon obtaining necessary entitlements beforehand. So Connections is in a unique predicament in that they have to plan for a project that relies on contingent funding. Additionally, any funds that are used for development projects are funds that are funneled away from current students. So while the application that Connections CBES submitted might not be on par with what the LUC generally receives, we submit that the application meets the minimum statutory and regulatory requirements for granting a special permit. My second point is that Connections proposal is unique. It straddles the line between a traditional school and an agricultural forestry program. As far as I understand, it's the first of its kind. The only comparable program I suppose would be the West Hawaii Explorations Academy, which is a charter school on the Big Island that implements a project-based curriculum. And they're a project-based curriculum that requires a specific location. And that's why they're located at the Natural Energy Laboratory in Kona. And so the proposed school doesn't fit neatly in the category of a traditional school, nor does it fit into the category of, an agricultural program solely. So as the record demonstrates, this clearly presents some exceptional circumstances. So therefore, we're urging the commission to at least consider Connections status as a charter school with finite resources, as well as the unique nature of the proposed project in reviewing the special permit application. Thank you.
Thank you. Commissioners, we can do questions one by one or just questions at the end. Seeing nobody jump forward, we can hold off till the end. Was Mr. Garcia going to say anything, Mr. Richardson?
Yes, good morning. Thank you very much for the opportunity. I would like to state that, as a school, it's very important to us that we are educating our students, particularly in mind of where we live on Hawaii Island, and part of the Ahupua'a that the Kaumana property is a part of. And so in regards to the concerns for preservation of cultural practices, indigenous and Hawaiian cultural practices, that's something that we is a part of our foundation as a school. And so we feel like we were diligent in having the reports provided regarding what could be found at this time, or at the time the reports were made, on the Kaumana property, on the lots there. And so, again, it's very important to us that as we educate our students and our families and ourselves, that we are cognizant of what it means to be Pono here in Hawaii, and to certainly respect the local culture, and to do what we can to preserve that. And the importance of helping our students to understand the opportunity to become a part of sustainability here on the island. And so we appreciate the opportunity to be before the State Land Use Commission, and hope that we can get your support in moving forward to continue to develop the school that we'd like to build on the Kamana property. Mahalo.
Thank you, Mr. Garcia. Mr. Hong.
Good morning, Mr. Chairman, members of the commission. Appreciate your taking the time to pay attention to our presentation and certainly our petition. I have 3 points that I want to make in terms of administrative matters. The 3 administrative matters that I'd like to bring up are: number 1, I'd like some clarification from Commissioner Chang under 15-15-3. I'm concerned about whether there was an unauthorized ex parte communication. When Mr. Matsukawa was called to testify, she referred to him in the familiar first person term, Mike. So I'm just puzzled, and I think my duty as an advocate requires me to inquire whether or not there's some kind of relationship with Commissioner Chang and Mr. Matsukawa. The second administrative point administrative matter that I'd like to bring up to the commission is whether or not the commission violated 92-7D of the Hawaii Revised Statutes by changing its agenda. It appears to have been a violation of changing the agenda without the appropriate vote. Third administrative point I want to bring up before I get into my closing statement.
If could you clarify, specify what agenda change you're alleging?
My agenda change, it's not actually an allegation, it's actually a fact. It was scheduled for, the meeting this morning was scheduled for 9 o'clock, and the commission changed it without taking a vote, without taking a motion, without any discussion, to 9:30 today.
Okay, please continue.
The third administrative point I want to bring up is Mr. Matsukawa's motion regarding the objection to the untimely filing by the County of Hawaii. He filed that. I don't have the file date, but I know that the certificate of service is dated January 12th, 2022. I was wondering whether or not the chair would like to take it up now and address it, because not addressing it without our opportunity to address it, I submit violates my client's due process rights. I don't want that particular factor or argument that Mr. Matsukawa made in his argument to be the low-hanging fruit for the commission to deny the special use permit this morning. So those are the 3 administrative issues that I wanted to
sorry,
raise.
Mr. Hong, can you repeat the third?
The third is Mr. Matsukawa's motion, and I'd like to know whether or not you're going.
Which motion?
On January 12th, 2022, he filed intervener Jeffrey Gomes's objection to untimely filing of County of Hawaii Windward Planning Commission's complete record with the State Land Use Commission.
Okay.
He noticed the hearing for January 19th to 20th, 2022 at 9 o'clock. So again, my concern is whether or not we're going to be given the opportunity to address those issues that he raised in it, because again, I don't want that to be the low-hanging fruit that the commission relies on in denying our special use permit.
Okay. Let's take each of these in turn. Commissioner Chang, do you wish to respond to the statements from Mr. Hong about your using Mr. Matsukawa's first name?
Sure. Thank you very much, Mr. Hong. I think being a member of the bar for such a long time, I've known Mr. Matsukawa for many years. I believe I may have also noted Jean Campbell by her first name as well. I have had no ex parte communication with Mr. Matsukawa in this case. I hope that satisfies your inquiry.
My inquiry is more specific in terms of working with him on specific cases or as co-counsel, or if you are part of any organizations, mutual organizations. I certainly would appreciate knowing that.
Sure. I'm a member of the Native Hawaiian Bar Association. I'm not too sure if Mr. Matsukawa is a member. I don't believe that Mr. Matsukawa and I have had, I don't recall whether we've had any cases together. We may have been on opposing sides when I was with the Attorney General's office many years ago, but I don't recall having any cases where we are co-counsel together. So, and clearly I've not spoken with him regarding this matter at all.
Thank you. I appreciate that because, you know, when we started this hearing, the chair was kind enough to, and I think ethical enough to disclose his contact with my sister. So I just wanted to make sure that in terms of commissioners, that everybody is, you know, fair and objective.
No, I appreciate that, Mr. Hong. So I hope that my responses has satisfied your inquiry. Thank you. Absolutely.
Thank you.
Moving to your second matter, what I called an allegation and you called a fact that we have changed the starting time of this meeting to 9:30, and we did so without a vote. I will turn to my Deputy Attorney General for further clarification, but let me share my first sort of response to that. I checked with the commission, and while we did not have a roll call vote, there was a consensus that this could happen. All the parties, I checked with you orally. Do you understand? You had every opportunity to object at that time if you felt somehow you were being harmed by the changing of things. In addition, we actually opened the Zoom meeting at 9 o'clock. And at 9 o'clock, there was a notice to the public, anybody who was noticing, that we were in recess and would be resuming shortly. And then we came in exactly what I had orally announced at 9:30. Ms. Chow, do you wish to add anything?
Sure. So guidance from the Office of Information Practices on continuation of meetings is normally that you have to announce at the meeting that it's going to be continued, and you have to indicate what time the meeting, what day and time the meeting is going to be continued to, and where the continued meeting is going to be. And you should be posting a notice at the site of the next meeting, but obviously in a virtual land, there is the posting requirements are a little bit different. So I believe those requirements were met when Chair Scheuer yesterday did announce the meeting was to be continued. It was going to be continued till today, and it was going to be continued until 9:30 today. So I believe all of the guidance and requirements that are set forth by OIP on continuation of meetings were met yesterday.
So if I may, Mr. Chairman, I disagree with your analysis. 92.7D does not require showing of prejudice. It requires a board, agency, or commission to take a vote to change their agenda. And that the agenda in this case would be when the meeting happened. And
I disagree with you. They did not change the agenda. The agenda refers to what matters are to be discussed during the meeting. There was no change to the matter that is to be the subject of today's meeting, and which is to be discussed by the Land Use Commission. And it's only the time that the meeting was continued until today. And the requirements for continuation of a meeting, which are separate and apart from the contents of an agenda, were met by yesterday's announcements.
Can I also pause for 1 second? I need to clarify, since you are co-counsel essentially on this, co-petitioner. Mr. Richardson, do you join in these arguments?
As to the argument about the agenda item, or all three?
All three, please.
As to the, okay. Sorry, I'm trying to remember each objection, but.
One was concern regarding the relationship of Commissioner Chang to intervener's attorney, Mr. Matsukawa. The second is concern regarding the manner in which the starting time of this meeting was changed. And the third is regarding an written motion filed by Mr. Matsukawa.
Okay, so with respect to the first matter, yes, we will join that objection. As to the second matter, no. To the third matter, yes.
So the first matter, regarding Commissioner
the
Chang,
inquiry,
you're joining in the objection.
All right, Mr. Hong's inquiry as to whether or not there were any ex parte communications.
Okay. Did you have anything further to ask Commissioner Chang about that?
No, I was satisfied with her answer.
And to the second?
We are not, we are satisfied with the LUC's counsel's explanation.
Okay, so we'll continue with Mr. Hong on this, and then we'll make sure to check in with you on the third.
Thank you.
Mr. Hong?
I think I made my record. Thank you.
So regarding the third item, a written objection. Sorry, Mr. Thatcher, I'm not sure why your hand is up. Okay.
My hand is up because I wanted to make a point that I am the one that asked Mr. Hong as my legal counsel to bring these points up.
Okay. So noted.
Thank you.
The third point raised by Mr. Hong is regarding a written objection in the record from Mr. Matsukawa. Let me clarify with Mr. Oradenker. Is this a motion for action that we have actually not dispensed with?
Mr. Chair, we don't have any record of that.
Chair, this is Riley. My recollection of what was submitted was only the notice of appearance of counsel. That's all I remember receiving, unless Mrs. King is.
Yeah, so it's not, so I'm not saying it's not in the record. It is a voluminous record, and I cannot out of my brain recite every single document that is written, but is this something that Mr. Hong, you received, or is posted to the website?
He sent it to me on the certificate of service, and we received it.
Was this served on the, can you confirm, Mr. Matsukawa, that you served such a document? And was it served on the other parties in this case?
I didn't file a motion. I filed an objection stating that I might file a motion after investigation, but I did serve it on the parties by mail and I think by email, including a copy,
on what date?
January 12th, including a copy to the executive director.
So you filed an objection to the late filing of documents.
Of the record on appeal.
Okay. And subject to your investigation, you just said you might file and you were considering filing an objection.
Yes, and based on my investigation and especially looking at the Perry versus Planning Commission case, I think the Supreme Court has looked at that particular issue as being directory, not mandatory. So as long as the commission is satisfied that they did receive the record, that's where it stands. So I have no motion. I just made an objection for the record.
Okay, and so to clarify, Mr. Hong, your concern is that this objection is on the record unresolved?
I think that would be accurate, yes.
So what is the remedy that you seek?
I'd like to ask Mr. Matsukawa to withdraw it, given his investigation. Either withdraw it or the commission should deny it. And I'm prepared to argue it if you'd like to hear it.
In some ways, the commission is satisfied with the receipt of the record on appeal. So,
Mr. Chair, can I interject here for a moment?
Please, Mr. Orodenker.
The filing of the record on appeal would have no prejudice against the parties. In fact, it provides them with additional opportunity. The county is required to submit the entire record of the proceedings to the Land Use Commission. Once the entire record has been submitted and it's deemed complete, the 45-day clock begins to run. And so regardless of whether those documents were received by the Land Use Commission with the original filing or a couple of weeks later, the only impact is moving the 45-day window. We would still have had to have had a hearing at this time. There would have been no additional time for the parties to prepare. There would have been no additional activity. It only, as far as from a procedural standpoint, the only thing it does is it moves the 45-day window down 2 weeks.
Mr. Hong.
You know, I'm on the side of the angels on this one because, again, I agree with Mr. Ordinaker. I mean, in terms of the record, I think the county transmitted it timely. And so I again asked Mr. Matsukawa, based on his investigation, to withdraw it. If not, if he doesn't withdraw it, he refuses to withdraw it, then I submit that I should be allowed to argue the point.
I believe you've actually already argued the point, but perhaps that is beside the point. Mr. Matsukawa.
Yeah, based on my investigation, and I contacted a couple attorneys who've done land use cases before the commission. I'm satisfied that the Perry case is controlling, so it's directory. If it came in, it came in. So I would withdraw my objection.
It's noted as withdrawn. Mr. Hong, I believe I've addressed all three of your administrative matters.
Yes, thank you very much. And I have—
Please give your final comments.
Thank you. In terms of my final or closing argument, I wanted to briefly raise 3 points, and then I have my conclusion. The first point is the Land Use Commission is engaging in unlawful rulemaking. The suggestion that the EA is stale is an arbitrary timetable in terms of the viability of an EA versus an EIS. This is not the Unite Here versus City case at 123 Hawaii 150. EIS is a statutory regulatory scheme that is fundamentally different from an EA. And EIS and the admin rules include a supplemental EIS. No such formality or requirement exists with respect to an EA, not even an implied one. In the Unite Here, they were looking at a 20-year-old traffic study. So where do you draw the line? To the extent that you draw that line, you are rulemaking, and to the extent that you believe that the EA in this case is stale, that's arbitrary and capricious. Second, a special use permit does not require final plans and financing, proof of financing, and to require us to do that, or to hold us accountable to do that, or to even say that this is incomplete or certainly not to a certain standard because we didn't provide you final plans or financing, That's not reflected in section 15-1595 or 2056 of the Hawaii Revised Statutes. 15-1595C is plain, ordinary, unambiguous language, says the 5 factors that the LUC has to consider are guidelines. And that's a quote. As much as you want to rewrite the administrative regulations and statute, holding us to a higher standard is wrong as a matter of law. Denying the permit, that you feel that a district boundary amendment process would be more appropriate, is also wrong as a matter of law. The LUC is supposed to focus on the use of the proposed permit or the proposal that's before it, within the guidelines of the 5 factors in 15-1595. The neighborhood board case at 64 Hawaii 265, again, is not applicable. Our proposed use is a small charter school, which would not change the essential character of the district nor be inconsistent therewith. That's a direct quote at page 271 from the neighborhood board case. For most of us, school is not a, quote, major recreational theme park, end quote, and to compare it to a charter school is a reflection of your intent. In the neighborhood board case, it involved 103 acres. The Supreme Court said it was a major commercial undertaking and that it would attract 1.5 million people annually. In this case, we have less than 400 students on a school day. We have less than 500 people on campus, including staff, on a regular day. This is form over substance. It's also form over substance in terms of a district boundary amendment, because in page 271, it discusses the factors of why a district boundary amendment process would be more appropriate. It says that a district boundary amendment process includes a public hearing and notice. Where in the record that has not happened in this case? The Supreme Court also pointed out that in a district boundary amendment kind of procedure or process, intervention is allowed on a timely application. Where has that not happened in this particular case? It talks about in the Supreme Court case that intervention can be freely granted. Where has that not happened in this case? It talks about rules governing intervention. Where has that not happened in this case? So other than wanting us to chase our tail until we run out of money or make it near next to impossible to obtain a district boundary amendment, maybe just to beat us into submission, what possible difference exists between a special use permit and a district boundary amendment when it's applied to this particular case, other than perhaps the entertainment value of laughing at us as we jump through more regulatory hoops? Changing the requirement in terms of a new guideline with respect to cultural assessment is also rulemaking. Instead of reaching out to them and have them respond in a meaningful manner, you are now requiring us, under the guise of the Hawaii State Constitution, to change the requirement, but you never tell us how. You said sending a letter is inadequate, yet the record clearly shows you that the Office of Hawaiian Affairs and the Department of Hawaiian Homeland responded to our inquiry. You said that Native Hawaiians don't respond to letters, yet we sent an inquiry to the Kanaka-Ole Foundation, one of the premier advocacy groups in East Hawaii, as you know from the Mauna Kea case. Your requirement is arbitrary and capricious because we are left to guess what is acceptable to you concerning community and cultural resource engagement. In our case, we had 6 advertised community meetings. We went door to door in the neighborhood twice. The mail out to property owners was 500 feet, not just 300 feet. We sent out letters and a questionnaire. Without any evidence, without any foundation, we speculate about why people did not respond to the letters in terms of cultural assessment. Importantly, you failed to provide any guidance. Should we hold signs out on the highway, fly a plane with a sign or message trailing from it without good vibes? You cannot hold us to a standard or requirement without telling us what that standard is. That is the template for a due process violation. The second point I wanted to make in my closing statement is that the LUC is deviating from its statutory and regulatory duty. You are to focus on the use, not the merits of the project. And the third point I want to make is we've been held to a double standard. I have continually represented from the beginning of this process that we worked in collaboration with the county's planning director at the time. We sat, we talked, and we discussed what the right vehicle was, and that was a special use permit. You have questioned my integrity with every party and their council, whether, quote, Hong talked to the county about the special use permit process, end quote. My client, both county attorneys, Mr. Darrow were interrogated. You wanted to show that I was lying to the LUC in front of clients, colleagues, and the general public. And I give credit to Mr. Darrow for telling the truth. I thank him for it. That was actually bravery. It would have been easy for him to say he couldn't recall or couldn't remember. But he remembered precisely what I had told you about how this happened, and then poof, no more questions. Along those lines, I have always followed the rules of professional conduct in terms of making truthful representations to boards, agencies, and commissions. I know that my license to practice law is not based on the shape of my eyes, my ethnicity, my bank account, my political party. That's why when I say something, I know it has to be the truth in the record, unlike some other people. I will bet good money that lawyers from the big downtown Honolulu firms do not have their integrity questioned in front of their clients and the general public by the commissioners. You know, the Tesla driving, Lexus driving, Infinity driving, Waialae Kahala Outrigger Club types. I'm sure the LUC lays down the red carpet for them when they step into the room. Me, the commissioners assume I'm lying and interrogate my clients and colleagues. And guess what? I'm not the one that's lying. In conclusion, you are trying to hold us responsible for the length of time in terms of the proceedings in this case. You have ignored the factors, which are the guidelines that you are required to focus on with respect to the use of the proposed property. The record shows that a charter school in a remote location at the bottom of a vacant large property in a rich Balfour neighborhood is an unusual and reasonable use. Thank you.
Thank you, Mr. Hong. Commissioners, questions? Seeing none. Ms. Kekai.
Thank you, Chair. Good morning, Commission. We'll keep this very brief. The Windward Planning Commission would just like to thank you for your service and the time that you've put into this, because if anybody understands the volume of this record, they do. Also, we would just submit that the commission found that this application met all criteria and thus would ask the Land Use Commission to approve it. Thank you.
Questions for the Windward Planning Commission? Ms. Campbell.
Good morning. Thank you, Chair, and good morning, Commissioners. I echo Ms. Kekai's thanks for your service. This is a long and arduous process, and this was a very voluminous record, very difficult for everyone to get through. I'll note that the Planning Department was and remains satisfied that the special permit application that they received and processed did in fact meet all of the county requirements for a special permit. And so the Planning Department continues to stand on its recommendation for approval. That's all. Thank you.
Thank you. Questions? Ms. Cotto.
Thank you, Chair, Commissioners. OPSD's position remains the same. We do not have additional comments. Thank you.
Mr. Matsukawa. Or sorry, questions for OPSD? Mr. Matsukawa.
Yes, thank you, Mr. Chairman, members of the commission. I just want to reiterate the points raised in our proposed findings that were filed with the Windward Planning Commission, to which there was no ruling as to why the proposals were being rejected. Specifically that the ICA had not rejected or vacated finding 47 as to adverse impact on surrounding properties and the inability for those impacts to be mitigated. That's binding and could not be rewritten. The ICA also did not vacate findings number 22 or 49 concerning Connection's ability to develop an adequate potable water system. The ICA also didn't vacate finding 57 that there would be an adverse effect on the essential character of the land. Now, this criteria is a county-based criteria. It does not appear in the LUC's rules. This is the county's own Rule 6, which adds this as a criteria. And it found the first time around that there was going to be an essential change in the character of the land. There was no appeal on this item, and the ICA never vacated that. In our proposed findings, we also addressed the failure of the Planning Commission to address the Public Natural Resources Trust. And we discussed that yesterday. And we also made note that the OSP had in fact filed a letter back in 2012 suggesting that perhaps a boundary amendment might be an alternative procedure for the applicant to consider. So that's in the record. It's nothing new. We also filed exceptions raising these same points, and I stand on that. Thank you very much.
Thank you, Mr. Matsukawa. Questions? Commissioner Ohigashi.
Yeah, I kind of curious about that, the additional criteria by the Hawaii Planning Commission. On this, on our review, are we required to determine beyond the, I guess, the 5 criteria, and must we consider the additional 2 criteria that the county has placed as a criteria for their issuance of special use permit? I'd like your comments.
I believe the general criteria set forth in the LUC's rules set forth the so-called guidelines. Now, nothing precluded the county from adding additional criteria as it chose to do, which was for this essential character of the land and compliance with the general plan. The fact that the county reviewed the evidence within those additional criteria, I think allows the Land Use Commission leave to look at what the county did and determine whether those additional criteria fall under one of the 4 guidelines of the LUC. And I think you could plug that in. The additional criteria would probably fall under, let's see, I'm looking at the board. Under guideline number 4, conditions, trends, needs. A sub-criteria, one might say.
And going back to our discussion yesterday, if we are to consider the additional criteria by the county has placed on, do we have to, is your position the same as before, that we have to, any one of now, I think it's 7 criteria, any one of the 7 criteria is sufficient enough to deny?
Yes.
And it's not the 5 criteria, one of the 5 criteria. In other words, we're not limited to denial or on the 5 criteria. And I'm not saying we're going to deny, but I'm just saying, I'm just trying to get that law concept in my head.
No, I understand. And I would say that to the extent the additional criteria falls under one of the existing Land Use Commission's guidelines, then it speaks for itself. If it's something unique, standalone, and separate, I think the Land Use Commission is looking, in a sense, at the county's findings to determine whether those findings are supported by the record. And if so, even if that is not a state criteria, whether the state in this review process can look to the additional requirements that the County Planning Commission may have utilized in its assessment of the application.
I have to mull over this a little bit more, but I want to assure Mr. Hong that I understand his argument that you have to look at all of the different criteria and judge and place and balance those criteria to make sure that a decision is determined that and no one issue should derail the special use permit. So I just wanted to assure Mr. Hong that I understand that argument. So I'm trying to understand that. And just as a passing comment, I drive the 2006 Honda Civic, and my wife and I share cars. That's for the record.
The chair, who drives a 2015 used Prius, wants to know if there's any other questions. Seeing none. Commissioners, I'm going to go into deliberation. What is your pleasure? I remind the commission, we can grant the permit. We can grant the permit with additional conditions. We can deny the permit. We could remand it for further proceedings. Commissioner Ohigashi.
If it's all right with the chair, I have a question to ask Mr. Hong.
Yes, I'm willing to entertain questions to the parties from the commissioners, but let me emphasize to anybody responding, your response needs to be narrowly tailored to the question asked. Please proceed.
Ms. Hong, I'm interested in your analysis of the neighborhood board case that has been sent. And I didn't have time to write it down, so I was just kind of unclear. Your first point was that this case is factually different because it involves a large 103-acre land use, or what was it, some kind of theme park type of case that is within the special use permit. Is that right?
That would, as the Supreme Court said, would attract 1.5 million people to that park annually. In this case, we have less than 300 students. We have, when even with all the faculty, actually it's less than 400 people.
I'm just trying to get, Mr. Hong, I'm just trying to get that you believe that it's factually different, that there's a substantial use in one case and not a substantial use in your case. Is that right?
That's correct.
That's why you differentiate.
That's correct, yes.
My question to you then is, I'm not trying to be argumentative. Where do we draw the line?
In terms of drawing the line.
Where do we draw the line? You tell me.
The Supreme Court at page 271 said, you have to look at whether it would change the essential character of the district and not be inconsistent therewith. And then you have to take a look at the particular use that's being proposed. And in that case, that is a substantial change with respect to use. In our case, it's fleas on a dog's back in terms of use. Because if you take your analogy.
For example, let me give you an example. If it was 40 acres and there was a small amount of industrial use being proposed on this. For example, like a garbage to energy type of plant or a recovery of recycling kind of plant at a landfill that has a special use permit. Would that change the nature and would an SUP be required?
So what you're suggesting in terms of your hypothetical is actually the facts matter. When earlier you had pointed out to me that the facts shouldn't matter, whether it's a major industrial, major theme park.
Hello. We're getting into
Tell me how to answer. Tell me how to answer, Mr. Chairman.
You're making an argument. I'm just asking you if that fact pattern would require a DBA or SUP.
And I'm telling you,
neighborhood board.
And that's a false argument. It's a false assumption because now you're saying facts matter in terms of the proposed use. I have always said that with respect to the neighborhood board case, you have to look at the proposed use. And what you just told me earlier, that the facts don't really matter. And now you're telling me that the facts do matter. So I'm a little puzzled in terms of how to answer that kind of question.
Commissioner Ohigashi, do you wish to further question Mr.
No,
Hong?
all I'm getting is an argument from him. And a personal attack on him. All I'm trying to do is find out under his reading of neighborhood board, where do we draw the lines? And you're telling me that I'm telling you that the facts don't matter. So I'm just asking you that question. But if you don't want to answer the question, fine, I'll go on. I am answering the question.
I would be happy to answer the question if you give me a reasonable question.
Hold it's just purely as an administrative matter. When two parties are talking at the same time, generating a transcript from this hearing is very, very difficult. So, Mr. Ohigashi, then Mr. Hong.
I don't have any other questions.
Thank you. Mr. Hong.
Thank you.
Nothing further?
Oh, I'm sorry, nothing further.
Okay. Commissioners, we are in deliberation.
Chair, I have a question.
Commissioner Wong.
So, okay, right now, it seems like no one want to do anything. What happens, let's say we lose quorum and nothing happens at that point in time? What is...
If we do not render a decision within 45 days, the permit is automatically approved.
Okay, thank you, Chair.
I would also note that there's a question, if it's automatic approval, what conditions would apply? And I don't think there's any determination of that. So if it goes into effect because the 45 days have run.
Can we get clarification when the 45 days will occur?
Mr. Ordenker. Thank you, Commissioner Giovanni.
The record was finalized on January 10th. 45 days from January 10th would be February 19th or 20th, I believe.
Mr. Chairman.
Sorry, did somebody, Mr. Hong, we're in deliberation.
I understand that. May I make a suggestion, or is that inappropriate?
Yeah, that would not be appropriate at this time. So I will start, commissioners, even though I love to defer to the collective wisdom of the commission. On one narrow issue, and this is an issue that I raised in questions, and a written response was given to us by Mr. Hong. Under Hawaii Administrative Rules 15-1595, and excuse me while I bring up the rule, Part A, it requires that an application for a permit, the record shall include evidence that the person requesting the special permit has written authorization of all fee simple owners to file the petition, which authorization shall also include an acknowledgement that the owners and their successors shall be bound by the special permit and its conditions. There are a number of records related to this matter, including the acceptance of a finding of no significant impact signed on behalf of Chair Thielen of the Board of Land Natural Resources at the time by Paul Connery. There is records related to the lease. There is an affidavit of the fee simple, or the lessor or intended lessor. I have not found in the record a clear and unambiguous statement from the Board of Land and Natural Resources or a designated representative that really specifies an acknowledgement that the owners and their successors shall be bound by the special permit and its conditions. Commissioner Ohigashi.
I think one of the problems I'm having is that one of the problems that I think is evident is that the conceptual concept of the school on its merits, it appears to be a good one. And it has notable goals. The amount of time it took to get here is of concern to me too. And I guess it's a frustrating thing to be at the end of any process, or at the so-called end of a long process. Having to review the record and having to make a decision. Also affords very, very, very difficult time for any kind of Then on the other hand, I'm bothered by the fact that we have clear statements within Planning Commission's findings that finds that a special use permit that this is not contrary, this appears to be contrary to objectives. The second thing it appears to be is that there's a finding that it unreasonably burden public agencies and provides roads, sewage, etc., school and fire protection. And it appears that there is a finding that, specific finding about that the desired use would affect surrounding property. But my dilemma is this. I think that a special use permit is just what it's called. It's for special purpose. And the legislature, I believe, as well, and intended it to be used for purposes that are not invasive towards neighboring properties. Essentially, these arguments will not adversely affect surrounding property. I think that in order to have a quick and proper process, I believe that these requirements are placed upon it so for the purposes of making sure that the proposed development meets those. In the other process, the DBA process, which is supposedly a longer and more cumbersome process, there is time, and as the chairman said, we don't necessarily deny people because of EIS problems or other problems, or because it adversely affects the surrounding property. But what we do is try to mitigate it in that form, and we wait, and we're balancing all of those interests. I'm not sure whether a special use permit requires, being that it's for that purpose to make sure that this development meets all this kind of criteria, allows us to do the balancing in a district boundary. And that's where my quandary lies. And I'm not sure that I would like to hear more argument, because the only way I can foresee us getting more argument on that particular issue, the balancing, because admittedly, like Mr. Hong says, this is not a 103-acre high burden fund type of project. This is a school. And I'm not stripping away, adding that into the mix does make the decision harder and may require more additional briefing on it. And the only other way I can think accomplish that is to remand it to the Planning Commission and ask them to brief some of these issues that we have brought up, so that we can have a clear record on the record as to the finding as to what this is all about. But I leave that up someone to make the motion, because at this point in time, I'm looking at this and I'm trying to weigh those things in my mind. Just trying to give my.
Thank you for your reflections, Commissioner Ohigashi. Commissioner Chang, followed by Commissioner Axon.
Thank you, Mr. Chair. My dilemma is, I applaud this project. I think it is innovative. I like the concept of integrating forest management, working with our young people. I think the young woman who provided testimony, very impressed with her. She was very articulate, and the school seemed to provide her a really nice fit. So I find that this school, what it offers, it fits a void in our educational process. So my dilemma is the purpose of the school, the function that it provides. But then I have to weigh that against what is before us. Before us is the Planning Commission's recommendation to approve a special use permit. So then I think we have to apply what are the legal requirements based upon this proposed use. The quandary I have is the Planning Commission, that the Planning Commission in 2014, based upon all the evidence, the same evidence that is on the record now, chose to deny the permit. The matter goes up to the ICA, and the ICA makes a conclusion. They uphold certain findings, but they remand it back and vacate the for other findings. And the Planning Commission chooses not to reopen the record. So the Planning Commission makes a decision in 2020 based upon the same record. No additional information, no additional, nothing new on the record, but they make a totally different finding and conclusion. So that I am just left feeling, it troubles me. But what it does, so what I'm faced with is looking at the rules, looking at the record that is before us, but also looking at the ICA opinion. And I look at the ICA opinion and it makes certain conclusions. And it found no error specifically with respect to the adverse impacts of traffic, notwithstanding the mitigation, the adverse effects of traffic by the proposed project on traffic to the surrounding properties. There is more than adequate testimony in the record by the surrounding property owners and others to support that. And the ICA likewise references the overwhelming testimony. So, I look at that. But then for me, I also look at what is our constitutional obligation. And we have an obligation under Article 12, Section 7, to preserve and protect traditional customary practices by Native Hawaiians. I find the record sent up by the Planning Commission to be totally inadequate to address Article 12, Section 4. When Mr. Hong says, well, what are we supposed to do? What's the guidance? Kapa'akai is the guidance. Kapa'akai provides 3 steps. 1, identify the resources. 2, identify the potential impact of the project to those resources. And 3, if there are adverse effects, what's the mitigation? What came up before us by the Planning Commission in the recommendations is totally absent of sufficient findings. The burden is on the applicant to provide sufficient information, and then the obligation is on, in this case, the Land Use Commission. So, so for me, that is an overwhelming consideration as I evaluate this, this SUP. It is our constitutional obligation, whether it was raised or not raised previously. So that is, I don't know if Mr. Axon, are you going to make a motion or are you just going to raise? Okay.
Commissioner Axon?
No, you're not going to make a motion. So if Commissioner Axon is not going to make a motion, well, I'll let Commissioner Axon.
I can call on Commissioner Axon and then call on
afterwards I'll make a motion.
Commissioner
Mr. Chair,
Axon.
if Commissioner Chang is going to be making a motion, I'll defer to her, but if not, I have something else.
Okay. Commissioner Chang.
It is with very heavy heart, because of this proposed, the project. I think it is a very, very worthy project. I think it's just not in the right place. So my motion is to deny the special use permit. And if there's a second to the motion, I'll provide my rationale.
I'll second that, Mr. Chair.
Okay, a motion has been made to deny by Commissioner Chang, seconded by Commissioner Axon. I will ask the movant and the seconder to specify the reasons for denial.
All right. Thank you, Mr. Chair. Based upon the record, the applicant has not provided sufficient information to demonstrate that their proposed project will not harm traditional customary practices exercised by Native Hawaiians, and therefore the LUC cannot fulfill its constitutional obligation to preserve and protect rights customarily and traditionally exercised by Hawaiians as required by Article 12, Section 7 of the Hawaii State Constitution, especially in light of the proximity of the project to Kaumana Cave. The applicant concluded that there is no evidence of traditional cultural properties or practices within the proposed area based upon a 2010 EA environmental assessment. However, the Planning Commission's findings of facts, conclusions in law, and proposed recommendations lacks any factual findings sufficient to support the conclusion as required by the court in Kapa'akai versus Land Use Commission. In addition, based upon the record, the traffic impacts caused by the proposed project will have an adverse impact on the surrounding properties as originally found by the Planning Commission and upheld by the Intermediate Court of Appeals. So those are the two rationales for at least the proposed motion. Thank you.
Commissioner Axon.
Thank you, Mr. Chair. Same as Commissioner Chang, I'm really, torn on this issue. As a person that sent my kids to public schools, I really support public school, and I believe that this charter school is important to education of our children. However, we are bound to our duties as land use commissioners. And the way I feel, the same as Commissioner Chang, the way I feel that the county just punt the case to us and say, hey, it's all yours. The planning commission, the VIII planning commission changed their decision based on what the ISCA decisions were without any justifications. So there are issues that came out during these discussions that could have been answered if the county decided, if the VIII Planning Commission decided to reopen the records. With that said, we are only bound to make our decision based on the records that was forwarded to us by the Planning Commission. That's it. We cannot, base our decisions on new records, but absence of those additional discussions or records, we are bound to what we have. So I support this Commissioner Chan's motion based on that. For me, there's a lot of questions that would have been answered if the Planning Commission just do their diligence in trying to answer some of those questions. With that, I will support this motion.
Thank you, Commissioner Axon. Commissioners, we have a motion before us to deny made by Commissioner Chang and seconded by Commissioner Axon. We are in discussion. Commissioner Giovanni.
Yeah, I have a question. Maybe it's a question to Commissioner Chang, or somebody could explain it to me. If this motion is passed and we deny the special use permit, in effect, does that just end the whole opportunity for this school to use this property to move to this property, or does it go back to the, is there an alternative where it goes back to the commission and they could come back to us again?
If I may, Commissioner Giovanni, a motion to deny certainly could be appealed by the parties. Assuming that a motion to deny prevails and an appeal is not successful, I believe that then the school still has its legal agreement with the Board of Land and Natural Resources on the lease and can pursue whatever entitlements it believes are necessary through this body or the Windward Planning Commission.
So, for example, hypothetically, if it gets to that point, the school could pursue a district boundary amendment, or it could go back and...
I believe that is the case.
Or it could pursue a special use permit under a reopening with...
And just in the interest of sort of expanding slightly beyond the question that you've asked, should we grant this permit, parties have the opportunity to appeal.
Sure.
And there would be a question of whether such an appeal would prevail or not. And then subject to that, then, yeah.
So I have not made my mind up yet whether I'll support this motion or not, but I am swayed heavily by the arguments of Commissioner Chang and Commissioner Axon, because I feel very much the same in frustration that when it was remanded by the Intermediate Court of Appeals, that the Planning Commission did not address the specific issues of the matter and basically punted it to us. That's my feeling. At the same time, part of my dilemma is that as much as that I would, as much as I see a voluminous record, it's incredible that we're still dealing with a concept of what this school would look like on this property and how it would operate and function. I would like for a special use permit to have a lot more application, to have a lot more detail in it. On the other hand, this is not a concept where it's a green site school for a green site location. The fact that it is an operating school in the Caress building already has 300 students and has a track record that is a good one, is meaningful to me and has a lot of credence to it. So I'd like very much for this school to find a permanent home, and this could possibly be it. But at this point, I'm still listening to the arguments and views of my fellow commissioners before I'll make a final decision on this motion. Thank you.
Commissioners, and we have 9 minutes until we need to go into recess till 1 p.m. Commissioner Chang?
No, Mr. Chair, that's the question I was going to ask you, is what's our time period? Thank you.
Yeah. Commissioner Ohigashi.
I was hoping that we would be able to consider a remand in this situation. However, I understand Don's position, Commissioner Chang's position. I'm sorry to use your first name, Commissioner Chang's position. And I understand feelings of everyone. And what I would like to request is that, and I know it's being selfish of me, but we would be able to recess this so that some of us can gather our thoughts and take a look at what is before us. Come back at 1 o'clock.
Commissioner Chang.
Yeah, I fully appreciate the quandary placed by Land Use Commission in this matter. And I've thought about this. Is it better to remand it back to the county based upon the same application, based upon the same record, based upon the same studies and the community's concern? And I recognize that the school has spent much more money than they had ever thought they would have to. But, you know, having a more, doing outreach, having an updated TIAIR, working with the county on perhaps a different, traffic route, looking at this in a much, in the lens of now 14 years or with 11, 12, 13 years after the original application. Maybe hindsight provides some lessons to both the applicant and the county, and maybe even DLNR. You know, is there an opportunity to refine this project and to now address the questions that were raised by the community, by the Land Use Commission, by the ICA? You know, is this time period so that you maximize your chance of success in getting an approval the next time? Because I am not as confident remanding it back to the Planning Commission is really going to be in the best interest of the applicant. You know, this may just prolong and delay, because I don't know what the inevitable is, but I think the alternative is revisit what exactly the project, a little more specificity, and updating some of these reports and studies that's part of my thought process and why I thought the denial would be more appropriate rather than a remand, because I wish I was more confident that on remand there would be a different there would be an outcome that may be different, but it may be better if they just start all over. So thank you. That's my comments to Commissioner Ohigashi.
Commissioner Axon.
Mr. Chair, I share Commissioner Chang's sentiment on this one. That was my first inclination about remand, but thinking about it, the county kind of pretty much sent us a clear message that they're done with this case. They did everything that they could do. They even ignored the intervener's motion or interveners proposed DNO, which I think would have been, if they opened the record, they would have been answered some of those questions. But remanding it to the county is kind of pretty much sending us, well, I said that the county just punting it back to us, and punting it back to them again is not really, things that I want to do.
Thank you, Commissioner. Commissioner Ohigashi.
I've mulled it over again, and I came to the conclusion that I'm going to support the motion, and this is more. I think Commissioner Chang is not only on the constitutional grounds, but specifically the findings that were left untouched by the ICARP. And in my mind, a special use permit, and the way I've been voting on special use permits has been to make sure that type of use fits all the criteria. And I think my vote on the Maui County base yard or the Maui County landfill is an example. I think that it's important for us to preserve what a special use permit is. And it's to make sure that those criteria listed have been met. The balancing of interests is properly done through a district boundary amendments. And that is what I believe should be done. Applicants agree to modify their proposal, come with a more small footprint and maybe take it out of our hands or anything like that. It's up to them, but or appeal this decision. It's up to them. But I'm going to support the motion.
Mr. Chair, I just want to let you know that I can stay for a few more minutes.
Okay. Thank you. Sorry, and Commissioner Giovanni, you also had a 11 o'clock. Can you stay a little bit longer?
I depart at 11. I must depart at 11, yes.
Okay, so it is 10:59. Commissioner Wong?
Call for the question.
Are the Commissioner Giovanni, are you prepared to vote?
Yes.
I would also add that denial is justified for two reasons. One is the lack of complete compliance with the requirements under 1515-95A for an affirmative statement from the landowner that they will agree to abide by any special permit conditions placed upon it. And in addition, I believe the record does not show that there is a concurrence as specifically required in law from the State Historic Preservation Division. I want to be very clear that my vote is based on those things and not on whether the school is a good thing or not. Because I personally feel, despite feeling somewhat attacked by certain counsel, this is a very worthwhile project, which I would like to succeed. And it's bothersome, deeply bothersome to me to, in that sense, to vote to deny, but I believe that's what the record requires us to do. Mr. Orodenker, please poll the commission.
Thank you, Mr. Chair. The motion is to deny the special permit based upon the record, and because the finding of fact lacks specific findings on various issues, including traffic impacts and Kapakai analysis with regard to the Kamai Cave. Commissioner Chang.
Aye.
Commissioner Axon.
Aye.
Commissioner Giovanni.
Aye.
Commissioner Ohigashi.
Aye.
Commissioner Wong.
Aye.
Chair Schroyer.
Aye.
Thank you, Mr. Chair. The motion passes with 6 affirmative votes.
Thank you, parties. There being no further business for the commission today, I declare this meeting adjourned.